we're still climbing a little bit, but I think we can get started. All right. So good morning, everyone. Welcome to the HR Roundtable. The HR Roundtable is a monthly seminar series brought to you by the 10 Positions group of companies. My name is Roger Oliver. I'm Director of Strategic Accounts, and started the HR Roundtable with my good friend and colleague Brian Bulger of Marsh many years ago, and we do it as a way to provide ongoing education and really just arm HR people to the teeth with the kind of information that they need to earn their seat at the table with the CEO and the rest of the C-suite, and to advocate strongly for the things that HR is responsible for, and a lot of the things that HR endeavors to do, and to sort of change that paradigm of very outdated paradigm of HR being looked at as a cost center, the personnel department, rather than a strategic department and strategic partner that is part of right in line with the C-suite, which is where it belongs. Just to give you a little background on, hold on one second. I'll share screens over here for a second. And where are we? Never a dull moment. Just want to share with you a little bit about the organization. So 10 Positions is probably best described as a multifaceted staffing solutions firm. We do temporary, temp hire, and direct hire across a really wide range of skill categories. We've got multiple divisions in order to make that happen. And you can see they're all branded with a name to reflect the different disciplines. So account positions for accounting and finance, CompuForce for a full range of IT professionals and solutions. HR Staffing Solutions is our human resources division. So when you need extra hands, we've got your back, and we provide all major disciplines of HR on all levels as well. On-Call Counsel is our legal division. So we are providing contract attorneys, paralegals, and other legal professionals. School Professionals is our education wing. We provide substitute teachers mostly to charter schools and private schools. And we are also very proud of the fact that we have an exclusive arrangement with the city to provide pre-K teachers for the UPK program. So whenever you hear a universal pre-K in New York City, we are the engine under the hood of that program, and very proud of that. Convention Services, sort of an offshoot of our hospitality division. Probably most of you don't have a need for this, but if you end up being saddled with the company party and you need waiters, bartenders, culinary professionals, we can do that for you as well. We have a very large footprint in healthcare, and specifically in social service. We provide RNs, LPNs, case managers, DSPs, all types of healthcare professionals for social service. We also staff the Vaccinate New York initiative for the entire state of New York, over 5,000 people. And we are currently staffing the initiative for Department of Homeless Services to provide care for the influx of asylum seekers and other individuals in that very vulnerable state. And lastly, logistics for warehouse and manufacturing environments. 10 positions proper for general office support, administrative, and clerical. And the Creative Bureau is our design division. All things web. Anyone needs to revamp their website or need copywriters, other communications professionals. That's what that division does. And lastly, is TGC Search, which is our division for executive search, which we do across a wide range of skill categories. So I'm going to stop sharing here for the moment, and I'm going to introduce our speaker, Joseph Harris. And Joseph is of the law firm of Barton LLP. And Joseph and I have known each other for quite some time. And Joe, if you want to grab it at this point and pop your, had this whole giant screen sharing rehearsal this morning. And while we're doing that, Brian, I want you to say hello to the folks there. I introduced you earlier, Brian Bulger of Marsh, and Brian assists with the HR Roundtable and created it back with me decades ago.
Yeah, good morning, everyone. I'm good friends with Roger. I know Roger well over 20 years, and I'm a mid-market employee benefits broker with Marsh McLennan. I also run a CFO HR roundtable on negotiating employee benefit contracts for a position of power. And I'll share that with Roger, my next upcoming event. And if anybody's interested in learning strategies on how to negotiate their employee benefit contracts from a position of power, you're welcome to attend, and I'll get that out to you through Roger. So good morning, everybody, and looking forward to today's session.
All right, so I leave you in the very capable hands of Mr. Joseph Harris.
Thank you, Roger, and thank you all for inviting me here to speak to you today. I really appreciate the opportunity. As you will see, employment law is one of those things I can really go on a tangent about, and there's so many things that we have to talk about today. Roger, if I'm rattling on and we're approaching, 10 minutes out, just wave a red flag or something, because this could basically go on.
No worries, Joe. And just for everyone on here, feel free to ask questions. We'll try to get to as many as we can, and please use the Q&A tab to ask the questions rather than the chat window. Pop them into the Q&A tab. You see that at the bottom, and we'll proceed that way.
And actually, you know what, Roger, if it's possible to do, I haven't done it quite this way before, but before the pandemic, obviously all of my presentations were pretty much in person, just like everybody else, and I would try to get a discussion group going, no matter how large the attendees were. So to the extent we can, maybe if you can just flag for me if a question is in the chat, and then someone.
Oh, I will.
I
will. I will interrupt, and I'll read the questions live.
Or jump in, or however you want to do it, but to make it something where it's not just me talking, I really would like to get everybody involved and have this be as much a dialogue as we can have it be. And then, of course, needless to say, to the extent we don't cover something that you want to talk about, which is almost guaranteed with a topic this massive, my contact information is at the very end of the slides, and Roger has it. So please do not hesitate to reach out if we don't get to anything.
We'll send we're going to send a message out to everyone following the presentation, and Joseph's email, and all of his information will be there. We'll CC him on that so that you can reach out directly with questions, anything that we don't manage to get to today. So go ahead and start us off, Joe.
All right. So this is, it's impossible, just in 2023 alone, it's impossible to cover everything that we would need to cover if this was going to be a comprehensive 2023 employment and specifically New York focused employment law update. So what I've tried to do is pick topics that I get questions about, that people seem to be interested in. Sometimes it's tough to decide what will be included and what won't be. So that's how we've made these selections. The fact that something is not on here, don't take that as somehow it doesn't apply, but we have to make editorial decisions in presentations like this. All right, so next slide. So it wouldn't be a legal presentation without a disclaimer right at the start. I'm sure you have all seen this disclaimer in one form or another. This is educational only. This is me giving you my personal opinions, not legal advice, and not the opinions of either my firm or Roger or anybody else involved. I cannot overemphasize the importance of fact-specific guidance when it comes to employment law. I realize that everybody here is in the HR space in some form or another, so I'm sure I don't need to tell you that, but especially when it comes to new developments where maybe the authority on it has not necessarily been quite so well developed, the importance of seeking counsel from your employment lawyer who knows your organization and can tailor the advice really cannot be overstated. All right, so why don't we start with the New York State pay transparency law, which is largely a mirror. There's some slight variations, but largely a mirror of the New York City pay transparency law that went into effect toward the end of last year. So most employers in the state are going to be covered if you have 4 or more employees. You're going to need to, if you're doing a job posting, you're going to need to include a job description if one exists, and then an accurate good faith estimate of either the minimum maximum salary range or rate of hourly rates that are going to be potentially paid. If you're paying on a commission basis, you need to say that it's commission-based pay so that that's not a surprise. This applies to all postings, internal, external, transfers, job boards, any sort of posting. There's protections for discrimination and retaliation. And then one key point here at the bottom, there's record keeping requirements. That's different than the New York City law. I don't believe the New York City law imposed a record keeping requirement. But then there is this can or will be performed from within New York. So that to me is pretty significant because you could have a situation where, what if the job could be performed from within New York, but you hire somebody remotely who works in another jurisdiction? Right there, that could create a multi-state employer consideration. So don't just think of this in terms of will be performed in New York. It's can or will be performed in New York. So in terms of what employers should do here, obviously, review your job postings to make sure that they comply with the law. Let me just jump back for a second here. On the good faith and accurate, the one question I get a lot of is, can we do an open-ended, minimum of X, but an open-ended, estimate? No, there needs to be a range. It can be a wide range as long as it is a good faith wide range. So that's the not open-ended piece there. So you want to make sure that you review your job postings for compliance. And then I would consider doing an internal pay audit just to make sure that the ranges that you're putting in your jobs, your job descriptions, your job postings are accurate. And then you also want to check for consistency between the roles that are currently occupied and the ones that you're hiring for. because a concern that I've gotten a lot of is, all right, well, we comply with this law, and then our current employees, let's say you're hiring for a particular job category department, the current employees either intentionally or they just stumble on it if they're maybe looking for other work, realize that you're offering substantially greater pay than they're being paid, and that can create some problems internally. So I think, being proactive and not just looking at the range and making sure the range is accurate, but also checking for consistency is really important. Drafting and reviewing job descriptions. One point on the job descriptions, and this is the flip side of a lot of these new laws, even though it does create some additional administrative burdens for employers and specifically for human resources, I think there can be a silver lining. And so the silver lining on this is it's a sort of a forced opportunity for you to review and update the job descriptions, not just for compliance with this pay transparency law, but job descriptions, I think, are often something that so many employers think of as an afterthought. Either they don't have them, or they haven't been updated in decades, or they're not using them properly, or they don't have them at all. And job descriptions can be helpful in many other contexts. So if you're talking about discipline and discharge, performance improvement plans, having a detailed, well thought out current job description can really help make any personnel decisions based on, let's say, a PIP, defensible, decisions not to hire somebody, decisions not to promote or to promote somebody, certainly in the context of reasonable workplace accommodations, having a job description that really identifies what the essential functions of the job truly are, as opposed to just listing 50 different things, or a 2-sentence description. That could be very helpful in determining whether an employee who requests accommodations can meet the essential functions of the job. And even wage and hour, I think, is potentially impacted here. Looking at the job descriptions and saying, does this job description, if I've got let's say an employee who I'm treating as exempt, does this job description actually reflect exempt job duties? Or if there's ever a dispute in a borderline situation over exempt, non-exempt status, does this job description, is this going to be something that, I would rather not have to produce in discovery? So even though this is going to probably make more work for everybody who's on this Zoom today, I think it will ultimately end up probably being well worth the time because of some of the collateral consequences of updating and making sure that they're current and properly drafted, your job descriptions. And then I would also consider possibly doing some kind of a pay equity audit. This is slightly different than, checking for range accuracy and consistency, which is the second bullet point, to determine, are there potentially lurking issues there? Maybe you don't realize it, but if you were to do a pay equity audit, you might find that there are unintended, but nonetheless, disparities in how certain groups are paid and how much they are paid. So that's something to consider as well. Better to do that proactively than to put all this information out there and then figure it out after the fact that you might have a problem. And with the pay equity audit, I strongly recommend consider doing that under the cloak of the attorney-client privilege, because no matter how compliant an employer you are, sometimes there are surprises. And if it's not a privileged audit, then it is fair game in discovery.
So we have a couple of questions here. Anonymous attendee asks, can you later increase the range if you find an ideal candidate?
Yes. So the issue is good faith at the time of posting, good faith and accurate at the time of posting. I think, if every so often or once, if it's a rare event that you actually extend an offer that's way outside the range that you post, I don't think that's necessarily going to be a problem. Again, good faith and accurate at the time of posting. But if, let's say, you develop a pattern where, your range for, I understand why an employer might do this, but your range of posted compensation always seems to be below the range that's eventually offered, I think that's going to be a problem. It'll be difficult to explain how, if this happens repeatedly, you are in fact making accurate and good faith estimates. So I think, a one-off is not the end of the world if it's truly just, kind of an unusual situation. But if you start to notice that it's happening a lot, I would revisit the ranges that are posted and say, how could this really be a good faith range if we're constantly going outside of it one way or the other? So that's a great question, though.
Yeah. Second question, can you hire someone without a job description, thus no salary range is provided?
Yes. Well, no. The salary range has to be provided, but a job description would not have to be provided under the state law if it didn't exist already. So it's the job for the state transparency law. If the job description exists, it has to be provided. But even if there is no job description, you're still obligated in the posting to, post the good faith accurate range. That's still required. I think that, if we're talking here as people in the HR space, I'm imagining that many of you probably get pushback internally on spending a lot of time on the job descriptions. And this might be the additional ammunition you need to go to whoever makes these decisions and say, look, I know that job descriptions hasn't necessarily been at the very, very top of our list, but with this new pay transparency law coming out, we have these one sentence outdated job descriptions. We're going to have to post them since we have them. It's really time to elevate that higher up on the HR priority list. So this might actually kind of give you guys a little bit of additional backing when you're trying to make the case for spending time on that. Because I know when I talk to clients about job descriptions, it's one of the things that I hear, well, we'll get to that, we'll do it, but right now we have to deal with this. And then they never quite get around to it.
Just one more question from Greg, and Greg, maybe you can rephrase this. He asked, will we need to keep the salary range on the job description under the law? I assume yes, but
and there's a record keeping requirement. You have to save. Let's see if I wrote it down. You do have to keep records of all the job descriptions and save them. I don't recall offhand how many years it was. Let me see if I noted it. Yeah, I don't recall offhand the number of years you have to save it. But if that's the question, feel free to email me. But you do need to save records, all the job descriptions that you're posting and providing, and the history of pay ranges that you're posting, that needs to be saved for at least a few years. If I were you, I would probably consider saving it for, at a minimum, 3 years. I would probably push for even 6 years. Because you're thinking, well, if you're going to make a claim under, let's say, the state or city human rights law, there's a 3-year statute of limitations, but some of the longer periods of limitation, let's say under the New York labor law, are 6 years in New York. So I generally will recommend that, unless there's a reason not to, that employers hang on to records, let's say 6 years after the employee leaves, so that you're well outside even the longest statute of limitation. But if you want to know the exact requirement on record keeping, just email me.
All right. And one more question. A few employees have relocated during the pandemic. They started in New York, but have moved elsewhere, and we have adjusted salaries to new location cost of living, parentheses, lower, to accommodate them and not lose talent. Do you simply document the accommodations in order to protect you if the salary range is ever questioned?
That's interesting. So I think, I mean, yes, I do think that is a good practice, so that there's some documentation there showing why it's suddenly lower. And I might have that acknowledged by the employee. That certainly can hurt, whether it's by email or in some sort of a formal document, having that acknowledged that that's the basis for the reduction. Because, you know, there's always lurking in the back of my mind when you're talking about a reduction in pay is concern over, well, what else happened during that time period? Or if it wasn't documented, what happened between the, you know, non-written agreement to do the reduction and the time the reduction occurred? Was there any sort of protected activity or protected disclosure? So I think documenting that and the reasons for that is a very, very good practice. I don't know if that answers it.
All right.
All right. All right. So this is another big one, and there's a lot of pieces here. So everybody is probably aware of the New York State human rights laws requirements when it comes to the settlement of sexual harassment claims, and how there's the structure of the 21 days to consider, confidentiality, and then 7 days to revoke. And that is a slightly separate topic, because I think at this point, most people in HR are well aware of that settling of a claim requirement. Here, what I'm focusing on is restrictions of confidentiality that would attach before there is any sort of dispute, whether directly or indirectly. So we have the Federal Speak Out Act, which is brand new. So this prevents confidentiality agreements that would prevent employees pre-dispute even from discussing the underlying facts and circumstances of a situation involving sexual assault or sexual harassment, the settlement of a sexual assault or sexual harassment claim, the terms of such a settlement agreement. That doesn't mean you cannot later enter into an agreement that is confidential and complies with the law, but you cannot, let's say in your onboarding confidentiality agreement, draft it in such a way that it would restrict them at the outset of employment before something has arisen from ever talking about future sexual assault in the workplace or sexual harassment in the workplace situations. It includes independent contractors, then the ending forced arbitration of sexual assault and sexual harassment claims. So similarly to the Speak Out Act, we're talking about just those two categories, and the Forced Arbitration Act, it allows the employees who are asserting these claims to avoid pre-dispute arbitration agreements that would require that whether these are brought individually or as part of a class or collective, that would require such sexual harassment and sexual assault claims to go to arbitration. So even if the employee signs the agreement, they can avoid it. I would not recommend saying, well, if all it's going to do is make it unenforceable with respect to the arbitration agreement, make it unenforceable with respect to sexual harassment and sexual assault claims, we'll just leave our agreements as is, and then we'll see what happens if we ever have to enforce it. I would strongly recommend consulting with your attorney about whether to expressly carve those out. It's still a relatively new law, and if arbitration is important to you, why take the chance on there being a question about overall enforceability? So I would think about that. In terms of, this is an amendment to the FAA, and it's not retroactive. So if you have an agreement that's in place, an arbitration agreement that was in place that did not comply with this prior to this becoming effective, you don't have to worry about making changes. Now, there's an interaction here with the New York State human rights law that is potentially interesting. So the New York State human rights law has a ban on arbitration, pre-dispute arbitration agreements involving claims of discrimination, unlawful discrimination. Now, just to make sure we're all on the same page, again, by pre-dispute, I'm talking about at the outset of employment, essentially. This law does not affect if you have a dispute with employee and for some reason they agree to arbitrate it rather than go to court. That's not what we're talking about here. We're talking about outset of employment. So the New York state law bans mandatory arbitration agreements that involve discrimination claims and that are pre-dispute. Now, there was a case before the Ending Forced Arbitration Act came out in which there was a challenge to the New York State human rights law. And the challenge was that the New York State human rights law directly conflicts with the Federal Arbitration Act, the FAA. And I believe the district court in, I think it was the Southern District of New York, agreed with the challenge and said that the FAA, trumps the New York State rule. At the time, it was only focused on banning pre-dispute arbitration agreements of sexual harassment claims. And so because of that decision, you could still technically have a pre-dispute arbitration agreement that would require arbitration of sexual harassment claims. However, the Ending Forced Arbitration of Sexual Assault Claims Act has occurred since that judgment. And the effect of that is, I think there was a case in New Jersey on this. I'm not sure New York has looked at it yet, but at least insofar as harassment claims are now concerned, because the FAA has been amended to now be in line with the New York State human rights law on this issue, you're no longer going to be able to have, in my view, or at least it'll be subject to a major challenge, pre-dispute arbitration agreements involving sexual harassment and sexual assault claims. So to sum up that long legal ramble, I think before this law went into effect, you probably could still have them despite the state of the New York State human rights law, because federal law, the Federal Arbitration Act, trumped the state human rights law. With the Federal Arbitration Act being amended by this new federal law, I don't think that's the case anymore. And I think it's going to be, the view is going to be that in New York, you cannot have pre-dispute sexual harassment, sexual assault claims go to mandatory arbitration. Okay. All right, so some of this I've already covered. One point on the New York State human rights law, pre-dispute confidentiality. You can have pre-dispute confidentiality, but only, so this would be in, say, an offer letter, an employment agreement, only if you have a carve-out that allows the employee to speak to the EEOC, the State Division of Human Rights, the New York City Commission on Human Rights, their attorney, law enforcement. If you have that carve-out, then you can have pre-dispute confidentiality, again, as long as there's that carve-out. And yeah, so I think what should you do here? Look through your materials. Don't just focus on whatever settlement of claims agreements you may be using, but look at onboarding materials. Look at non-disparagement and confidentiality restrictions. I say non-disparagement because often people forget that that's sort of the backdoor way that you can cover yourself on confidentiality. So don't just think about confidentiality, think about other terms and conditions in an onboarding agreement that would somehow restrict the ability of an employee before a dispute arises to make claims about sexual harassment or sexual assault. Obviously, look at your arbitration agreements. If you're a New York employer, I think at this point you're going to have a very difficult time enforcing pre-dispute arbitration agreements that don't carve out sexual assault and sexual harassment claims. And then I would also consider alternatives to mandatory arbitration. I mean, a lot of clients, they sort of think of it as an all or nothing situation. I don't think it has to be that way. So maybe before, your preferred approach was to have, mandatory final and binding of any type of employment claim that you possibly could, including sexual harassment. All right, if you're a New York employee, you can't do that now. But what you could do is consider, for example, mandatory pre-litigation mediation. So there's nothing there in which anyone's waiving their claims. There's no decision being made. It doesn't prevent them from going to court. But my experience, especially with sexual harassment claims, has been that mediation can be very, very effective. So as long as the requirement is not onerous and it's drafted reasonably and is not going to prejudice the employee, I think you would have a good shot at having a mandatory pre-litigation mediation provision put in there. Once you get the ball rolling with that, a couple hours of mediation with a really good mediator, even if the employee still legally could file their claim in court, I think your risk of having some kind of a public dispute is probably dramatically reduced as a practical matter. And then the other thing I would think about is in your agreements, okay, you can't have these subject to mandatory final and binding arbitration for pre-dispute sexual harassment and assault claims. But if the concern was, unpredictable juries, consider including jury trial waivers. So again, it's still public. You're not getting the same kind of confidentiality that you would in arbitration, but you do have some security knowing that a single judge will make a decision on the facts and that it's not going to be decided by a jury, which is always a coin toss, especially for employers in New York. So think about those either separately or together or any other alternatives as you're deciding what to do about the mandatory arbitration of sexual harassment issues. Another thing is, since COVID, pretty much almost every employer that I work with, regardless of industry and regardless of size, has, at least for a period, often unintentionally become a multi-state employer. They have people who are working all over the country for them, sometimes full-time, sometimes part-time. But if you have people working from other jurisdictions, then you cannot look at this solely, say, through a New York lens. The jurisdiction where the employee is physically working from on a regular basis and living, that is likely to give them an additional layer of protection. Certainly if they decide to go to, say, an equal employment opportunity agency in those jurisdictions, they're still going to have protection of those laws, regardless of what your contract says. So think about some of the different states that might impose similar but not the same or different restrictions on confidentiality as it relates to sexual harassment claims. So for example, California, Illinois, Washington, New Jersey, those are some jurisdictions, there's probably others, that have specific rules on this that you should consider. Like Illinois, for example, truthful statements about unlawful harassment, discrimination, or retaliation. Those are, cannot be part of a confidentiality agreement. Conduct in Washington, the state of Washington, conduct that violates EEO laws. New Jersey, details of a claim of discrimination, harassment, or retaliation. California, unlawful acts. So even if you're a New York employer and you have most of your people in New York, still have to think more broadly, because post-COVID, I think we are all either full-time or some of the time multi-state employers. Any questions about that before I go to lactation breaks and nursing employees? Oh, you may be muted, Roger. Sorry.
Oh, yeah, no, I'm good. Why don't we, Walter, why don't you throw up our poll question, to sort of take everyone's pulse on the economy a little bit and sort of the hiring picture. And Walter will pop that up when he's, oh, here we go. Okay, so how has the current economic climate affected your company's hiring plans? We'll see where folks are at. Always a great thing about live polls with a good size audience. And we have nearly 100 people on here, so we'll see where folks are at. All right, very good. We had one question left over from the about the sort of out-of-state employee question from Hero Dukas is asking which state's tax laws prevail for an employee residing outside New York place of employment.
So I am not a tax lawyer, full disclosure. I think that, so one, check with your accountant, check with your tax lawyer, but something to keep in mind if you're a New York employer with people outside of the state of New York working in some other jurisdiction, is the New York convenience of the employer rule. And this is something that I think there's now greater awareness of, but it's still a little bit obscure. If the reason that the employee is working outside the state of New York, and we're not talking about somebody is, working remotely from home, in New Jersey for a day or a few days, but somebody, relocates or is working on a long-term basis in a different state, and they're performing work for the New York employer where they have a New York office, and the employee could be there, but as essentially a courtesy or an accommodation to the employer is permitting that employee to work remotely and live outside the state, then New York's position is that individual employee, again, they work for a New York employer and they could work in New York, but for the accommodation of the employer, that New York employee still has 100% of their wages subject to New York state income tax. So an employee who, let's say, relocates from New York to Florida, thinking that they're going to avoid the New York state income tax on their wages because they live outside Florida. Maybe they only travel to New York, for company parties or training sessions, once every quarter or once a year even. It is likely, again, check with your tax lawyer, but it is likely that under the convenience of the employer rule, that unless that employee is down in Florida because you're opening a Florida office or something, that employee, 100% of that employee's wages are still subject to New York tax. So that is a trap that employers and employees fall into. They may also be subject to tax obligations in, if they're not in Florida where there is no state income tax and they're in a state that does have a state income tax and they're there most of the time, it's possible that they might have obligations there as well. But I would check with your tax counsel. But the New York convenience of the employer rule, it's only one of 5 or 6 states that has this rule. And it's counterintuitive because I think a lot of employees and employers think, well, if you're only in New York for 1 or 2 days a month or 1 or 2 days a year, then at most you're only going to be paying 1 or 2 days of New York state income tax. And that is not how it works in the state of New York. So watch out for that. Oh, you're muted. Sorry.
Yeah. Joe Posner asks, what if a person was hired on condition of remote hire versus someone who from the pandemic decided never to come back and we approved as a courtesy to them as you described? So there is I cannot overstate this enough. If we're talking about taxes, this is really, tax law comes up in employment law a lot, but when that happens, I bring in a true tax lawyer. But I will say there is a very onerous test that applies if you want to say that a New York employee who is working remotely is not subject to the convenience of the employer rule, i.e. is not subject to New York state income tax. And if you Google New York employer convenience rule test, probably one of the first hits will be from the New York State Department of Tax or Finance
and it'll give you the breakdown. But the test is very, very difficult to meet. There's two categories that have to be satisfied. And essentially, what they're looking for is somebody who is in the remote jurisdiction. This broadly speaking, they're in the remote jurisdiction in order to effectuate the business purposes of the employer. So, like if you have a plant that is in another state and you have hired this individual knowing this person's job is going to be to supervise employees in this plant. Okay, perhaps that might be the kind of situation. Or if you're opening an office in a remote jurisdiction and this employee's job was to work remotely from that jurisdiction in order to manage this office, perhaps. There's a bunch of factors. I mean, it's not just one or two. It's a long list of factors. It's very challenging to meet by design. But if it's just, hey, we're going to hire this person and they could do the job in New York. We have space for them to work in New York. We are a New York employer. Occasionally, even if very rarely, they come to New York. And the only reason that person is permitted to work remotely is because they want to, and you're being a generous and accommodating employer. Chances are that employee is probably going to have a New York State income tax problem. Certainly, if they left the state of New York, even if they left before they came to your workplace, if they left the state of New York, went to a more tax-friendly jurisdiction and are still now working, even if it's a new employer, for a new New York employer remotely, the New York State Department of Tax and Finance is going to be on the lookout for people who have done that. New York State lost something like, I think it was 7% of its entire tax base last year. So they are going to be on the lookout for people who are leaving the state of New York and suddenly not reporting that income. So I would definitely check with your CPA or a tax lawyer on these issues. And the other issue is if you have employees in a remote jurisdiction, there's a pretty good possibility that you're going to have to pay taxes and register to do business in that jurisdiction. So before you just agree to hire anybody in any location, I'm going off on a tangent here, but it's critically important. You should think about what the business registration, tax implications, and other implications will be on your business. For example, non-competes. You may have a non-compete that would be enforceable in New York. It's narrowly tailored, beautifully drafted. Council's approved it. You hire this person, you're going to work in the state of California. They sign it in California and work remotely from the state of California. You may have a problem there. So, the multi-state employer issue really impacts almost every area of the employee-employer relationship, and consequently, what the issues that HR has to consider.
All right, quick couple of questions. Hero Dukas asks, with regard to bringing children to the workplace, can an employer prohibit, employees from bringing kids to work?
My gut reaction is probably yes. I think you could, yes. I mean, but I would, in your policy, first of all, that would need to be pursuant to that's the sort of thing where you would want that to be pursuant to a written policy, neutrally drafted and applied to everybody. And there would need to be, I would want to see some sort of a, something in there that explains the rationale, which I presume would be safety or distraction, something like that explains the rationale. For example, I represented a physical fitness studio a while back, and they had a rule that visitors, including children, so it wasn't just limited to children only, but visitors, including children, that might be the safer way to do it, had to stay in the waiting area. They didn't want people running around a gym, potentially damaging or hurting themselves on equipment. So I would, if you're going to include a policy like that, check with counsel. My gut reaction is if it's a neutral, equally applied policy that's in writing, that contains a legitimate business reason for the restriction, then I think that's probably fine. Do you have particular concerns about it?
No, we'll see if she replies. In the meantime, we have one other question. Would consultants count as employees towards making one a multi-employer? That was probably that was an earlier question, earlier item.
That is a very, very good question. And this is actually, I might hold that question for the independent contractor segment of this, because it's a great segue into that independent contractor, freelancer, consultant, whatever title you want to give them, into that whole issue. The short answer is, it depends on the law. So some laws do protect contractors, some laws don't. But even for the laws that don't protect contractors, and again, we'll get to this in a bit, I would strongly urge that employers think very carefully about how they're classifying their employees or their workers as contractors versus employees, because an error in that domain can have ripple effects in wage and hour, unemployment insurance, taxes, leave laws. If you have somebody, let's say, who's working remotely, I'm going to assume, let's say you have 50 people plus working for your organization. You have an individual who's working remotely, and you agree you're going to pay them, as an independent contractor, and you're going to pay them X per week, flat salary. If it turns out that your classification, even if it was signed in an independent contractor agreement, and the other side agreed to it, the employee or the worker agreed to it, if that classification was legally erroneous, you might owe that person overtime. You might have tax liability because you won't have been paying FICA and Medicare taxes on the wages. You might have unemployment insurance contribution liability. You could have non-coverage of worker comp penalties in the state where they are. If they have requested any sort of sick leave or time off and you've denied it, you might have FMLA interference or paid sick leave law interference liability. So even though some laws don't protect contractors, some laws do, I would urge a renewed look at the contractor issue, because it seems to be all over the place that narrowing the scope of those who can be considered independent contractors, that is a focus of regulatory agencies, including the National Labor Relations Board and the Department of Labor. And I think it's only going to get more intense. And it's also the source that even unintended good faith misclassification of a worker as an independent contractor or consultant is often the source of some pretty unfortunate lawsuits against employers, particularly in the overtime area. So I would take a look at that regardless of the particular law.
All right, very good.
All right, let's do nursing employees. Okay. I'm going to zip through the Federal Pump Act because most of what's covered here is going to be covered under the New York State law. So you have to give reasonable time to express breast milk. This is an expansion of a previous 2010 law affecting lactation in the workplace. So you have to provide a private space, whether it's a room, a separate room, or if for some reason you can't do that, a separate space that is private, shielded from view. It cannot be a bathroom. It cannot be a toilet stall. The breaks can be unpaid. You have to give them this accommodation for up to 1 year after the child's birth. One word of caution on the unpaid breaks being okay. Always a reminder to employers to think about how they treat unpaid versus paid breaks in a larger context. So here, under this federal law, unpaid break time is fine for expressing breast milk. But think about, are you giving other types of break time that are paid? And if you're giving other types of break time that are paid, but only, let's say, the lactation breaks are unpaid, could that potentially be a problem, even if you didn't intend it to be so? So when it comes to this law or the New York law or any other type of law that provides for time off during the workday, think of it in a larger context of your time off and leave laws more generally, and how does it fit in there to make sure that even if you're complying with the technical requirements of this law, you're not doing so in such isolation that it creates a perception of some sort of adverse treatment. All right, so the New York law, that goes into effect in a couple of months in June. There's already a New York City law that's in effect. The state law is very, very similar. So private location that is not a bathroom has to be well lit, private, and close to the work area, has to include certain things. So a chair, a flat surface, and they say if your workplace has electricity, which I can't imagine it doesn't if you're on a Zoom call, then it must have an outlet there, needs to be close to a source of water, a sink or something like that. The employees have to be able to use let's say the break room refrigerator to store breast milk. There needs to be, the State Department of Labor is going to distribute a policy that you can use and that you'll be required to use to notify employees of their rights. And you're going to have to do that upon hire every year and anytime an employee returns after childbirth. If an employee requests access to, the lactation space or the lactation room, you have to get back to them within 5 business days. The period of time in which this law applies the protection is 3 years following childbirth. The federal law is only 1 year. Use when necessary. So you can't say you're allowed 2 lactation breaks per day. If they need 2, they need 2. If they need 5, they need 5. If they need 3, they need 3. They can take as many as they need. They can either take it on an unpaid basis, or if they want to, they can be allowed to use paid break time. Again, think about this in the larger context of how you treat other break time during the workday. And then, of course, protections from discrimination, retaliation for employees who request lactation accommodations. So employer to do, identify how you're going to accommodate this, whether it's a particular room or if that's not possible due to, let's say you're a very, very small employer and there just isn't an additional room that could be used, some sort of separate, shielded, private space that you can set up so that you're not scrambling in that 5-day window to figure out how you're going to comply with this when you do get a request. Sooner or later, you're going to get a request for this, so get out ahead of it. And then, needless to say, the training of supervisors, I cannot overstate that. They are acting on behalf of the employer in many of these cases. And the worst thing is for a supervisor who either doesn't respond at all or doesn't pass it up the chain or dismisses it as, that's ridiculous, we're not giving you that, or why should you get that? No one else gets that. So really, this is a good opportunity to do an annual training and to include that in the annual training to remind them, even if they're the supervisor aren't going to handle it themselves, to make sure that it gets to you in HR so that you can handle it properly.
A couple of questions here. One from Carol. Is running water required in the lactation room or simply nearby?
It says nearby.
Okay. And Angela asked, could remote work count towards an accommodation for nursing employees?
No, I think this would be, let me just jump back to the question about the running water. So under the state law, it says nearby. Double check, or if you want me to double check, just email me and I'll double check. The city law, which is already in effect, has almost exactly the same requirements, slightly different. I don't recall whether the city law requires the running water to be in, the near vicinity or actually in the room. I think it's nearby, but I'm not 100% for the city law. So if you're in New York City, just email me and I'll double check. But the state law is nearby. On the remote, if the question is, and I apologize if I'm not trying to straw man this, but if I'm not accurately describing the question, please tell me. If the question is whether whether the employer could say, you're entitled to go home and work remotely if you need to, or work remotely during the period where you are needing to express breast milk, I don't think that's going to fly, because I could see somebody saying, I mean, I understand the argument. I completely understand the argument. Letting them work from home is a way to accomplish this. But the law is really specific about the required necessity, and essentially saying to an employee indirectly, even though it's not meant this way, I could see somebody trying to argue, my client, I'm putting on my plaintiff side hat here, my client requested accommodations under the law and then was told they had to go home and couldn't be part of the workplace for the next 3 years because they have to express milk during the day. They were essentially excluded from these social events, from being in the workplace, and that affected their promotions and pay because they were told, get out. So even though it's not intended that way, I understand that. I could see an argument that an employee side lawyer could make against an employer who tried to accommodate in that way. So I would be cautious about that. Now, if the employee,
Angela did say that, yes, that is the question.
Yeah, unfortunately, it's it's a totally reasonable question, and but I think it's always helpful to look at employment decisions through both the lens of things are good and we're trying to accommodate and be constructive, but also the lens of, all right, everything's fallen apart, and the only people looking at this really, really closely are people who are going to try to argue that we did it wrong, and to see if you can conjure up a way in which the offered accommodation is somehow could be construed against you. And if I were representing an employee in a case like that, that's probably the argument that I would make.
All right. I think we got a poll question just about people's how well suited people feel to deal with compliance issues. Walter, you want to throw that up?
And I'm just going to step aside for 1 second while you do that poll. 1 moment.
Okay, here we go. How confident do you feel in your organization's ability to comply with employment laws and regulations? Always a handful. That's why we have these sessions. We'll see where that shakes out for everyone. All right, vote, vote, vote. While we wait for Joseph. So I see when, all right, so those answers will come up as soon as they're, oh, here we go. All right, so most people feel somewhat confident, and good, nobody in the not confident at all. And I guess the 7% who say not very confident, maybe you need to reach out to Joseph, or or counsel of your own, just to feel like you've got better, you've got your feet underneath you on a lot of these topics, and it's complicated, and it is an ever moving goalposts here. Hero asks, will the presentation be provided as is, including the Q&A presented? I don't know if it does or not. Walter, is the Q&A sort of there in the? I mean, obviously everything we're saying is going to be in the video. So this session is being recorded for anyone who wants to know, and you can use the link, the same link you used to log in to access the video, and it's usually available pretty shortly after we conclude the program, certainly I think by the next day. And you can also forward it to anyone else in your organization that you think needs to have this information as well. So, and then they also remain up on our website for you to access at any time. And so you can go to our website and see a whole previous topics as well. And there's some good stuff on there. All right, so go ahead, Joe.
Just one word about that poll for a second. I especially directed to the people who said somewhat. I often describe employment compliance as a little bit like the famous scene from the movie Apollo 13, where Tom Hanks is being asked to build an air filter out of all of these random things on the spaceship. The spaceship's flying around, it's careening out of control, it's venting oxygen into space, and Tom Hanks, in order to save the astronauts on the ship, has to take all these different things that were never meant to create an air filter and make an air filter. And I feel like that is really your job as HR and my job as employment counsel in the world of employment law. We have all these different sources of employment law. You've got state courts, federal courts, state agencies, federal agencies, local city agencies. You've got common law, you've got federal statutory law. You have all these sources of employment law. They're not necessarily coordinating with each other. They're not necessarily concerned about whether all of these will fit nicely together. And somehow we all have to come up with a way to make all of this work so that the organization can function. It's actually probably a little bit even harder than the air filter example, because when Tom Hanks was doing this, the size of the pieces didn't keep changing, to Roger's point about it being an evolving area. So I think for those who said somewhat, that's a completely understandable reaction. And I think also demonstrates that we all recognize that this is a very complicated and dynamic area, and it is a challenge to stay on top of it. So, okay. Lawful absences. So this is relatively new. It's an amendment to the New York labor law. So it's a prohibition on retaliating against employees who take any, quote, legally protected absence under local, state, or federal law. This goes on top of any other provision that may exist in any other local, state, or federal law prohibiting retaliation. So for example, sick leave, if you retaliate against an employee for taking, say, New York City or New York State paid sick leave, there would be consequences. Retaliation for taking FMLA, consequences. This would be added on top of it as an additional consequence. One interesting thing here is that this could create a situation where, I haven't seen this done, but just thinking about it as I was putting this together, where laws that might not necessarily provide a private right of action in a court would create an opportunity for an employee side lawyer to bring an action in court. So for example, New York State paid family leave, if there's if you retaliate against an employee for a violation of the paid family leave law, the initial recourse is going to be through a proceeding, an arbitration. It's not going to be through a private action in court right away. Here, however, I could see an argument that, well, retaliating against an employee for taking paid family leave, whether that's by not rehiring them or not returning them to the same or a comparable position, is a violation of the law. It's retaliation, and therefore there's a private cause of action that could be brought in state court simultaneous with an action being brought administratively for the violation of that law. So it seems like, well, what's the big deal? But I think it creates a potential minefield, additional liability risk for employers. The other reason is that we have, so there's civil penalties of between $1,000 and $20,000, depending on the circumstances and whether it's the first or second time, lost wages, other damages, private right of action. And I believe that it also includes attorney's fees. And anytime there is a fee shifting provision in an employment statute, I think you are likely to see a spike in claims arising under that law. It may take a little bit of time for it to get traction, but I think this does create some substantial additional risk for employers on lawful absences. What this was designed to do is target so-called no-fault attendance policies. So, the most common version of this is, you get 10 absences per year, and on the 11th, you're placed on a disciplinary step, and then on the 12th, you're terminated. Just an example of how it might work. And the company says, we apply this regardless of the circumstances. Everyone is treated the same way, and that's the rule. And on its face, that sounds fair. But, of course, as HR professionals, when we look at that and say, well, how would that apply in the context of somebody who might need a reasonable accommodation? How would that apply in the case of someone taking intermittent paid family leave or sick leave? You could see a situation where what appears to be a facially neutral policy actually could disparately impact people for taking legally protected absences. So that's what this was designed to prevent. But because it does create this additional layer of protection on top of the already existing law, I think we are going to see a lot of claims arise under this. Now,
We have a question.
Cool.
I'm sorry.
No, please.
Okay.
No, I'm going to slightly switch topics, so this is a good time for a question.
Okay, so can a manager legally deny time off if there's available PTO?
I would be careful, because I think it. So if you're saying, can we require somebody to use PTO if they have any left before taking a statutorily protected leave? My gut reaction is the default should be no. There are some statutes that expressly say you cannot do that in New York. Certain forms of COVID leave, for example, they're very explicit that the leave is in addition to any other leave provided under any other either state law or existing, policy of the employer. I believe the New York State paid sick leave law has the same position, where you cannot say, we're gonna take from your PTO. So my default would be assume no, but if you wanted to look on a case-by-case basis, that I would consult with counsel on. Because the other thing would be, let's say you have a vacation. Oh, sorry, go ahead.
Oh, yes, he said it would be regular PTO.
Yeah, I would, my default on that would be assume no unless you consult, that you should not do that unless you consult with counsel, and under the circumstances it's permissible. Because, for example, like with the COVID leaves, where they expressly say you cannot require an employee to use, accrued PTO before taking COVID leave. You can't require them to exhaust that. There are a number of statutes like that, even outside the COVID context in New York, that say you cannot require the employee to use accrued PTO before taking, before taking unpaid time off.
All right, this is very, you definitely you definitely struck a nerve here. Not struck a nerve, but I guess brought up a good point here. Everyone's chiming in. Tara asks, can we withhold pay when an employee has gone over their paid time off?
Yes, if an employee has exhausted their paid time off, and I just want to be clear before I continue with that answer on the previous question about using PTO. I'm not saying that if someone has used all their PTO and they want to just take more time off because they're on vacation or take just feel like not coming in, they have to be given unlimited vacation. I'm not saying that at all. What I am saying, though, is I would default to the more conservative position of, if, let's say, an employee has 5 days of accrued PTO and they say, I want to take, I need to take COVID leave, for example, I would not say, all right, well, you can't take the COVID leave yet because you first have to exhaust all your PTO. Some statutes expressly prohibit that, others might not, but there could be disparate impact considerations. So I would default to no, but if you want to get to yes, I would check with counsel on an individualized basis. On the other question of whether you have to pay somebody after they've exhausted the statutorily required paid period, the answer is going to be no. If they've exhausted all of their paid sick leave, for example, and they need to take more paid sick leave, and let's just look at this in a vacuum, not affecting any other laws that may be implicated, you would not be required to pay them for additional paid sick leave beyond what is required by the statute. However, since we don't ever exist in a vacuum and we're back in, the Apollo 13 space shuttle here, trying to fit all these things together, if someone is telling you, I've used all my paid sick leave, I'm done, but I can't come in, I wouldn't just drop the hammer and say, well, we'll see you tomorrow or don't bother coming back, because you very well may have some kind of circumstance that would necessitate, let's say, paid family leave. Maybe they're caring for somebody who's a loved one who would qualify for the paid family leave provisions, affecting caregiver status. Perhaps they have some sort of FMLA qualifying condition where it's not paid, but you couldn't exclude them. Perhaps there's a workplace accommodation, even if there's not FMLA. Perhaps there's a situation that involves short-term or statutory disability where they've exhausted their paid sick leave, but they need to now go on, paid disability. So even though you may not need to give them more pay under the statute, I wouldn't end the analysis there. And I would think, how could this request potentially impact the other pieces of the air filter to really torture this analogy to death?
All right, so we've got 4 questions on this. Let's try and bang them out. We're about we're a little over 10 minutes out. I'm sure you have other about 10 minutes remaining scheduled, so I know we got a lot to go through. So lightning round on these questions here. So short, quick explanation. What evidence can be requested for COVID leave? And then asking the PCR test is that what evidence is evidence required for COVID leave? Do you ask for evidence or?
So please email me about that, because that wasn't something I was planning to get into detail on.
Okay.
Today.
All right. So yeah. So please email Joseph about that, and I think a lot of questions. We'll try and take some more, but we've got to speed up here to cover more topics.
Just one footnote on that. The COVID leave stuff is a minefield. The COVID paid sick leave is going to remain in effect until the end of this year, so it's still worth knowing about and having updated policies on. You used to have to go get something from the doctor certifying the amount of time you were out. Now you can do a self-attestation. The Department of Labor has taken the position that if you're going to exclude somebody from the workplace just because they were exposed, you're going to have to pay them for the time they're out. The size of the employer makes a difference. It's a minefield, so just email me.
Okay, will do. So Simone and Carrie, those questions, just email them directly to Joe. All right, moving along.
Should I go to our next?
Yeah, go.
All right, I'm going to go because we have 10 minutes left. So I want to just highlight a couple of things. I'm more than happy to talk in more detail about any of the topics that we didn't get to today, but I'm just going to zip through so that if you're looking at the slides after the fact, you have some context for what I was going to talk about. Next slide, New York Labor Law 740. This is the New York whistleblower law. Bottom line is you now have a law that protects current and former employees and independent contractors if they disclose or threaten to disclose to a supervisor, or they say any public body, but essentially any agency, any conduct that this employee in good faith and reasonably, which is very, very broad as we know in employment law, basically not a lie, reasonably and in good faith believes violates any law, rule, or regulation. It's a extremely broad law. It's an expansion of a law that used to be incredibly narrow. There's a notice of rights from the Department of Labor, and it provides for a private right of action with the potential for substantial damages and attorney's fees. Frankly, I'm kind of stunned. I haven't seen more claims on this already, but it basically sneaks in a anti-retaliation provision with fee shifting into almost any law, even if it doesn't have an express one. So watch out for anything related to retaliation. Train, train, train. All right. The Helix Energy decision, bottom line, the United States Supreme Court decided less than a month ago that an executive, a employee who had executive job functions, there was no dispute about that, and was paid over $200,000 a year on a day rate, that the day rate was greater than the minimum weekly salary threshold under the FLSA, $200,000 a year, US Supreme Court says that guy gets overtime. Why? Because he was not paid a guaranteed weekly minimum salary, even though if he worked one day, because he was paid so much, his 1 day of pay would exceed the then applicable guaranteed weekly minimum. But because it was a day rate and not a weekly salary, US Supreme Court said no go. $200,000 a year gets overtime. So I've included a couple of tips as you're thinking about overtime that you can look through that are either direct or indirectly from the Helix decision. Highly, highly recommend, if you have not in the past few years done a privileged, and I emphasize privilege, otherwise it is fair game in discovery, privileged wage and hour audit, now is the time to do it, especially with the changes coming with independent contractor classifications. If it's not privileged and you do the audit and then you don't actually make the changes, now you've got evidence of willfulness. So a privileged audit is the way to go. Next big topic, the National Labor Relations Board recently issued a pretty broad sweeping decision that found that these confidentiality and non-disparagement terms, there's 2 slides here that show you the actual language from the agreement, that these violated the National Labor Relations Act and were unlawful. And so I have included some guidance on what to do from here in terms of non-disparagement clauses. The key takeaways in our, the 5 minutes that we have are: 1, even if you don't have a union, this is a problem for you. The National Labor Relations Act, Section 7, provides protections for completely non-unionized environments. So everybody on the call needs to take note of that. And also, the provisions of the NLRA protect both current and former employees. And don't just think about non-disparagement and confidentiality clauses. Think about how these terms, which are in the slides and you can email me about, could be present in things like post-employment restrictive covenants, like employee non-solicit agreements that would restrict employees from talking to each other. So here, let me go here. Right, so I can include some guidance on, how to, potentially modify your provisions that would potentially hit on some of this. Yeah, non-assistance clauses, offer letters, employment agreements, policies. Don't just think narrowly about this. On the consider slides, consider this, consider that. I'm not saying necessarily do these things. These are, employers are going to have to decide based on their risk tolerance, the industry they're in, public profile, what they do, whether they want to take any of these guidances from the NLRB's general counsel or not. These are things to consider, not necessarily immediate action items. So you're aware, this clause here was proposed by the general counsel of the National Labor Relations Board in a brief that she submitted recently as an example of a disclosure that might go into a handbook, which would, in her opinion, this is not the law yet, but in her opinion, the existence of this clause in a handbook should provide the employer with some degree of cover, again, not the law yet, but this is her position, that the policies that are located nearby in the handbook don't restrict Section 7 activity. Whether you want to include something this broad or not, this is a council discussion to have. But the old, this does not, restrict you in Section 7 rights is definitely not going to fly anymore under this board. So if that's your savings clause, it's not really saving anything any longer. The ban on non-competes, I'll sum it up like this. Reach out to me if you have questions from the FTC. The bottom line is this: it doesn't even matter what happens with this rule, even if it's tied, it's still in process, even if it's tied up in litigation and doesn't ultimately go into effect. States and localities are moving, including New York, to try and restrict non-competes. So the time is now to do a privileged trade secret audit. And I give some flags on how to do what the things you want to look for are. But again, privilege. If you don't do it privileged, it's subject to disclosure. So the silver lining is it's a reminder for employers to really focus on trade secret protections in a matter-of-fact, day-to-day way. Don't depend on restrictive covenants to save you anymore, because no matter what happens with the FTC, the tide is against restrictive covenants right now. You got to make sure your trade secrets are protected. And then finally, or two finals, was the independent contractor rule. We are going back to a holistic test. It's no longer going to be the Trump DOL 2021 rule with two basically dispositive factors. We are going holistic, case by case. I provide some guidance on that. LLCs will no longer shield somebody. The fact that someone brings their own tools will no longer shield someone. The fact they have other income will no longer shield from an independent contractor misclassification finding. The fact that someone has to comply with legal requirements to work for you, that could be indicative of control. The fact you reserve control on delivery of materials in your independent contractor agreement can now be used against you if this rule is finalized in its current form. So, and then workplace policies to watch. And I was going to go through some examples, but reach out to me if you want some.
Yeah, Joe, you can share the slides with us to provide to folks afterwards, right?
Oh yeah, this is
okay. Yeah, so we'll make sure that that you get the full slide, so that if you have questions on individual pieces, you can reach out directly to Joe on that. Did you want to finish this point here, Joe?
No, I think that I summed it up. The overall is this. This is an opportunity, whether it's with the pay transparency law and job descriptions, whether it's with the FTC's proposed ban and trade secret audits, whether it's with the independent contractor rule in the Department of Labor. Even though this is going to create headaches for HR, and I think it's going to create potential exposure, a lot of exposure for employers, this is an opportunity to go back and revisit a lot of these things that maybe we haven't had a chance to look at in the past few years, and really take a holistic view at what the practices are and say, are there other ways that we can be protecting ourselves that we haven't necessarily been because we could rely on other things and to get ahead of it. But be proactive, I think, is the name of the game here. It's going to be a bumpy few years for employers.
All right. Thank you so much, Joe. This was terrific, and we'll definitely have you back and do more. Anyone on the call who did not get their invite directly, maybe somebody shared it with you. If you would like to be on our distribution list for future HR roundtables, just write back to the email that you received with the invite, which should come to me, and I will make sure to add you to the HR roundtable list for programs going forward. And with that, I thank you all. You have Joseph's contact information there in the chat window. If you want to grab it, cut it, and paste it out of there before we wrap, and you'll also be receiving a follow-up email with the slides, and video will be available as well. And with that, we thank you all. Joseph, thank you so much.
Thank you so much for having me. Thank you all for your time.
And everyone, have a great rest of your day. The sun is shining. Get out there and have a good one. All right, Walter, take us out.
Thank you.